Representation, we are calling it
On the right-hand side. You're correctly placed. I thought, of course, when I came in this court where the sports over, demonstrates, especially that you trial, find a way for the jury. It's not for us to see how it should be done. But this time they are correctly placed at the end of the day.
You were not yet present at the last day of mention, but no one also. This is the judgment of court. I will release the notice of motion dated 28th of November 2022. The plaintiff is taken action in the Supreme Court titled SCC 2022. to invoke the original jurisdiction of the Supreme Court pursuant to section 124 and 127 of the Constitution, Act number 6 of 1991, praying for the following beliefs. A declaration that on a proper and purposive interpretation of section 38A of the Constitutional Amendment Act number 15 of 2001, the controlling provisions stipulated in subsection 1 thereof, namely, but constituencies have not been established, are conditions precedent to warrant or justify the holding of the general election of the ordinary members of Parliament by the district block system, hereinafter referred to as the proportional representation system. B, a declaration that the directive by the President to the Electoral Commission of Sierra Leone, ECSL, to hold any public elections for ordinary members of Parliament by the proportional representation system where there are extant and subsisting constituencies is ultra vires the Constitution 1991 as amended. C, a declaration that the current Parliament was itself elected on a constituency basis as provided for in sections 38(1), 2, and 3, and that these constituencies are still extant and subsisting. D, a further declaration that revision of constituencies as provided for in section 4, subsection 4 of section 38 does not necessarily result in the establishment of constituencies stipulated in section 38, 1, 2, and 3, but that rather the section provides for the period existing constituencies should be reviewed, which revision may or may not necessarily result in the limitation of the respective boundaries of existing constituencies. E, a declaration that will rely on section 38A of the 2001 Act, as stated by the second defendant in their press statement, would preclude independent candidates from contesting for Parliament as contemplated in section 77M of the Constitution of Sierra Leone, Act number 6 of 1991. F, a declaration that the entirety of section 38A of the Constitutional Amendment of 2001 does not provide nor contemplate local councils elections. The word basis on which local authorities were last elected is the subsisting and lawful basis on which any public elections involving local authorities can be held and not the proportional representation system. G, an order restraining the second defendant, its agents, servants, privates, or howsoever from taking any steps aimed at conducting the June 2023 multi-tier public elections on a proportional representation basis. H, an order directing the second defendant to hold the June 2023 elections for ordinary members of Parliament on a constituency basis as presently established. I, a declaration that section 2 of the statutory instrument number 83, dated 16 November 2022, making provision for both proportional representation for members of Parliament and local council elections, is authorized section 33, 38 of the Constitution 1991. The application was supported by the affidavits of Honorable Abdul Kago, Member of Parliament representing constituency 077 in the Putloko district in the northwestern region of the Republic of Sierra Leone, and Councillor Hakiratu Maxwell Cocker, elected councillor for Ward 414 in constituency 118 in Freetown in the Western District. The first and second plaintiffs, respectively, both sworn to on the 28th November 2022. On the affidavit of the first plaintiff, Honorable Abdul Kadir, was attached two exhibits, namely Exhibit AK1, which is a true copy of Clause 57 of the Public Elections Bill 2022, and Exhibit AK2, which is a letter dated 15th November 2022 from Joseph Fitzgerald Kamara Esquire of JFK and Partners, solicitors for the plaintiff's hearing, to the Secretary to the President, requesting for the Secretary to the President to furnish them with a copy of the Presidential Directive issued to the Chairman of the Electoral Commission to conduct the June 2023 elections on the basis of the district block representation system. On the affidavit of the second plaintiff was attached one exhibit, with Exhibit HMC1, which is a copy of the press statement dated 21st October 2022 from the second defendant hearing. Accompanying this originating motion, notice of motion and affidavit in support of motion, was the plaintiff's statement of case, also filed on the same date, the 28th of November 2022. The defendants had 10 days thereafter service on them of the plaintiff's papers without leave to file a statement of the defendant's case. Service of the plaintiff's papers was effected on the 30th of November 2022, and on the 8th of December 2022, both defendants obliged this honorable court with statements of the defendant's case. Taking cognizance of Rule 97.1 of the Supreme Court Rules Public Notice Number 1 of 1982, which states that, quote, this court may, after considering the statement of the plaintiff's case and of the defendant's case and any argument of law, decide to determine the action and give judgment in court on a fixed date without argument. I have taken liberty to produce herein, despite their length, a verbatim production of the plaintiff's and defendant's case. Statement of the plaintiff's case pursuant to Rule 92 of the Supreme Court rules. Facts and particulars of the plaintiff's case. The first plaintiff was elected as an MP in 2019 to represent constituency 77 in the Bukloko district in the northwestern region of the Republic of Sierra Leone. The second plaintiff was elected as councillor in the Freetown City Council in 2018 for Ward 414 in constituency 118 in Freetown in the western area of the Republic of Sierra Leone. Both plaintiffs were successful candidates for the All People's Congress Party in the aforesaid elections. Since their election, the respective constituency and ward of both plaintiffs are still extant and subsisting, and they have not been delimited by division nor disestablished by law or otherwise. In 2022, a bill entitled the Public Elections Bill was introduced in Parliament. Clause 57 of the said bill provided as follows: quote, a general election of members of Parliament other than paramount chief members of Parliament shall be by A, the one-member constituency system under subsection 2 of section 38 of the Constitution, or B, the district block representation system in accordance with section 38A of the Constitution, as set out in the 12th schedule, unquote. During the first and second readings of the bill, it was evident that there was strong and vocal opposition to the bill insofar as it purported to introduce the district block system of voting for the ordinary members of Parliament. The Speaker of Parliament, perhaps sensing the mood of Parliament, later unilaterally withdrew the said clause 7 from further consideration by Parliament. The Speaker then pronounced from the chair that proportional representation system of election was already part of the laws of this country in light of the amendment introduced by section 38A of the Constitutional Amendment Act number 15 of 2001. Then, on the 21st day of October 2022, the Electoral Commission for Sierra Leone issued a press statement in which it stated that on the directive of the President of Sierra Leone, it would use the district block voting system. contained in the amendment to the Constitution introducing Section 38A thereof. Submissions. In the forefront of and central to the plaintiff's case is that, given the provisions of Section 38A, amending the then Section 38 of the Constitution 1991, the June 2023 multi-tier public election for the country on proportional representation basis, as stated in the Electoral Commission of Sierra Leone ECSL press statement dated 21st October 2022, for the plain and simple reason that the condition precedent to bring Section 38A into operation, namely, quote, where there are no constituencies are not present, as there are extant and subsisting constituencies provided for in Section 38(1) of the Constitution 1991, and local wards as provided for in the Local Government Act 2004. Therefore, it is submitted for the plaintiffs that to conduct the 2023 would offend the controlling provisions stipulated in Section 38A of the Constitution, to wit, where under any law for the time being in force, a date for a general election of members of parliament has been appointed, but constituencies have not been established in accordance with subsection 3 of Section 38. For the purposes of such election, the President may, after consultation with the Electoral Commission, direct that such election shall be conducted on the basis of the existing district in a manner to be known as the district block representation system instead of constituencies, unquote. It is further submitted that the trigger, if you will, to bring proportional representation system into play for the purpose of elections in the country is, quote, where constituencies do not exist, unquote. Therefore, in the face of existing constituencies and wards, the forthcoming elections for parliament and ward cannot lawfully and properly be held on the basis of proportional representation. The predicate where in section 38 is all important in the context of the meaning and effect of the section. The word itself intends to be a technical term in legislative drafting. It normally and best conveys the equivalent of general circumstance or a description of a factual situation. See Legislative Drafting Volume 1 by VCRAB 1993, reprint 1998, Cavendish Publishing Limited, page 40. The plaintiffs respectfully urge this honorable court to take judicial notice of the fact that the present parliament comprises members who were elected during the last general elections in 2018 to represent their respective constituents, and the same applies for the current members of the local authority. These respective constituents and wards are in being, vibrant, and subsisting. This, it is respectfully submitted, is the key and substance of the plaintiff's case. There are present subsisting constituencies and wards in the country for electoral purposes. This should, in or by itself, preclude the cost and proportional representation system of elections as provided in Section 38A of the Constitution. It is further submitted that proportional representation as contemplated and provided for in Section 38A of the Constitutional Amendment of Sierra Leone 2001 is itself a product of its time. It is a fallback position when there are no constituencies or wards for the purposes of public elections in the country. This was the rationale and the prevailing circumstances that warranted and justified the amendment introduced to Section 38 of the Constitution 1991 and 2001 as now contained in Section 38A of the Constitution. The country had then just come through a brutal and destabilizing rebel war foisted on the country, which resulted, apart from the loss of human lives and destruction of property, in the destabilization of communities nationwide. An immediate effect of such dissociation was the absence of settled community and constituencies. Hence, the justification for this was in a bid to restore the country to democratic civilian rule. It then was seen as a contingency provision and not intended to be a regular format for public elections or general elections. This is borne out by the operative words of the amendment in section 38A, but constituencies have not been established. The amendment introduced by section 38A clearly speaks to a situation where constituencies have not been established. It is further the case for plaintiffs that these conditions do not now prevail in the country, and therefore the courts cannot lawfully and properly be held to constituencies and wards. Moreover, it is the case for the plaintiffs that a review and possible delimitation of constituency boundaries as provided for in section 38(4) of the Constitution 1991, or warrant that in the absence of such review and delimitation, recourse can be had to the proportional representation system. This is so for the simple reason that a review of boundaries of constituencies may or may not result in their delimitation. Section 38A of the Constitution only stipulates the time frame within which such a review may be done. It is further submitted for the plaintiffs that failure to embark on or complete such a review of boundaries exercise does not ipso facto result in the abolition or elimination of such constituencies, so as to warrant the bringing into play of proportional representation system for electing the members of Parliament. Therefore, in the present circumstances, it is submitted for the plaintiff that there is no warrant or justification for the use of proportional representation for the forthcoming elections. It is further submitted for the plaintiff that the use of proportional representation for public elections would negate the possibility of having independent candidates for such election, as is contemplated in section 77N of the Constitution, which relates to the loss of an elected independent seat on cross-carpeting to a political party. Moreover, it is the case for the plaintiffs that the proportional representation system gives primacy to a political party's list submitted to the Electoral Commission to the exclusion of the constitutional entitlement of every Sierra Leonean, subject to the requirement listed in section 35 of the Constitution 1991 to be entitled to be eligible as candidate for Parliament. The proportional representation system was intended for the conditions specified in the amending section 38A of the Constitution, and it was not intended to deprive Sierra Leonean citizens of the right to stand for and be elected as members of Parliament by a mere side win, as is now contained in the second defendant's press statement. It is further submitted for the plaintiffs that since exceptional circumstances in 1996 and 2002, when the course was had for public elections to the proportional representation system, subsequent elections up to the present for Parliament and local councils have since been on constituency and ward basis. The exceptional circumstances were in 1996, the destabilized state of the country had, on the heels of military interregnum and the civil war, desire to return the country to an elected civilian rule after a combination of civil war and military interregnum between 92 and the year 2002 marked the official end of the civil war and the subsequent restoration of parliamentary constituency. Therefore, it is submitted for the plaintiffs that the use of the proportional representation for parliamentary elections and local councils election was done in those exceptional circumstances which do not now prevail. Accordingly, it will not be conducive to democratic civilian government in circumstances of a multi-party system to hold public elections now on a proportional representation system, which would be a throwback to an earlier unsettled state of affairs in the country. The plaintiffs have invoked Section 1241 of the Constitution 1991, which provides as follows. The Supreme Court, quote, the Supreme Court shall, save as otherwise provided in Section 122 of this Constitution, have original jurisdiction to the exclusion of all other courts. A, in all matters relating to the enforcement or interpretation, emphasis added of any provision of this Constitution. And B, where any question arises whether an enactment was made in excess of the power conferred upon Parliament or any other authority of persons and law or under this Constitution, unquote. That is to say, respectfully, this honorable court is being asked to interpret, apply, and if possible, enforce by way of granting the several reliefs prayed for by the plaintiff in this matter as contained in the notice of motion. In this exercise, it is respectfully submitted that the task of this court is simply, if regard is had to the basic principles and well-established canons of interpretation of statute. It is submitted respectfully that the first of these is that if there is nothing to modify or alter the language of the statute, it must be construed in the ordinary and natural meaning of the words and sentences used. This, it is all respectfully, is the literal rule of interpretation, which cuts down the ages since the 19th century have employed. See the judgment of Judgement MR in Attorney General and Mutual Tontine Westminster Chambers Association Limited and Lord Fitzgerald in Radcliffe against Clark. Again, it is respectfully submitted that the objective of all interpretation is to discover the intention of the lawmakers, which is deducible from the language. Once the meaning is clear, the court should give effect. The courts are not to repeat, the plain meaning of an enactment by an introduction of their own words into the enactment. Given the constitutional scheme of Section 38 of the 1991 Constitution, which stipulates that Sierra Leone shall be divided into such constituencies for the purpose of electing the ordinary members of Parliament, unquote, it is submitted that ordinarily such election should be on a constituency basis. We say so because Section 38A amending the Constitution envisages an extraordinary situation where no constituencies have been established, one reason or the other. This, on the evidence, is categorically not the case in this instance. See the affidavit of the first plaintiff, paragraph 1 and 3. It is respectfully submitted that the salient words used by the legislature in Section 38A, amending the Constitution 1991 as follows, quote, where under any law for the time being in force, a date for a general election of members of Parliament has been appointed, but constituencies have not been established in accordance with subsection B of Section 38 for the purposes of such election. The President may, after consultation with the Electoral Commission, direct that such election shall be conducted on the basis of the existing districts in a manner to be known as the basic block representation instead of constituencies. Unquote. In later, in enacting this section is clear and simple, namely where a date for general election has been appointed, but no constituencies exist in accordance with Section 8B of the Constitution, then and only then we submit the President may, after consultation with the Electoral Commission, direct that such an election shall be conducted on proportional representation basis. What is the evidence in this case after that? Clear from the press statement by the Electoral Commission itself a date for the general election has been appointed, namely the 24th of June 2023. Also clear as a pipeline is that there are existing constituencies and wards established pursuant to Section 38 of the Constitution 1991 and the wards under the Local Government Act 24, boundary number 2 of 2008 respectively. It is accordingly submitted respectfully that the press statement of the second defendant stating that the 2028 elections will be held on a proportional representation basis finds no validity or affirmation in the clear and plain words of Section 38A of the Constitution. It is further respectfully submitted that Section 38A of the Constitution does not give the President carte blanche power to direct that elections be held on a proportional representation basis, regardless of the controlling words of the section, namely what constituencies have not been established. Unquote. It is therefore respectfully submitted that to find or hold otherwise is to fly in the face of the clear words and plain meaning of Section 38A1 of the Constitution and the weight of evidence in this case. The unconstitutionality of statutory instrument number 83 and 83 of 16 November 2022. Paradoxically, it is to be noted that these statutory instruments, given the same number, purport to address both parliamentary and local council elections, respectively. The claimed one authority for this instrument is Section 33 of the 1991 Constitution. It is submitted respectfully for the plaintiffs that this section confers no authority as claimed in the said statutory instrument to change the form, format, or mode of parliamentary and local government elections. Section 33 of the Constitution undoubtedly confers on the Electoral Commission the power to make. Section 33 of the Constitution undoubtedly confers on the Electoral Commission the power to make regulations, but such regulations cannot change the form of elections for parliaments and local councils as purported claimed in the statutory instrument. It is again respectfully submitted for the plaintiffs that to change the form of election of members of parliament and local authorities is a deliberate matter for primary legislation. The form for electing a member of local authorities is specified in the Local Government Act 2004, more particularly in subsection 4 of section 4. The power given to the Electoral Commission under section 33 of the Constitution and section 171 of the Public Elections Act 2002 is to conduct and supervise elections and not to determine the form or mode of elections. To change the format, mode of elections, it is submitted a matter for primary legislation, reserved for the legislature, and with respect, not the subject of a statutory instrument. The word conduct in the circumstances does not include prescribing the form of election or changing the electoral system. Section 68 of the Public Elections Act 2022 enumerates what constitutes conduct of election by the Electoral Commission. Nowhere in the entirety of Section 68 is it suggested that the Electoral Commission can change the form or mode of electoral system. The powers exercised under the statutory instrument by the Electoral Commission are in excess of the powers conferred under Section 33 of the Constitution 1991 and 171 of the Public Elections Act number 17 of 2022. In conclusion, it is urged respectfully that on the law and the evidence, in this case, it will be ultra-vires and unlawful to hold the June 2023 elections on the proportional representation basis for the following reasons. Firstly, such elections on a proportional representation basis would obtain the clear provisions of Section 38A of the Constitutional Amendment 2001. This section simply provides that the President, in consultation with the Electoral Commission, the direct latter to conduct such elections on a proportional representation basis where constituencies have not been established. Second, on the evidence there are currently established and existing constituencies in the current parliament of this country. Thirdly, the contingent circumstances envisaged in Section 38A of the Constitution as amended are not present to run a proportional representation system for the 2023 elections. Fourthly, it will be wrong and impermissible in a democratic state to invest the president with the sole power to order and direct a proportional representation system for public elections without the concurrence of parliament and in the face of existing constituencies. Fifthly, it is for all these elections that the plaintiffs beseech this honorable court to grant the reliefs seek in their motion. Sixth, the proposal to hold the June 2023 election on a proportional representation basis would flout and ignore the constitutional scheme stipulated in Section 31 of the Constitution. This provides that Sierra Leone shall be divided into such constituencies for the purpose of electing members of Parliament or courts, which provision was amended in 2001 by the Constitution of Sierra Leone Amendment Act number 15, 2021, by inserting paragraph A to Section 38 as follows: quote, where under any law for the time being in force, a date for a general election of members of Parliament has been appointed, but constituencies have not been established in accordance with subsection B of Section 38. For the purpose of such election, the President may, after consultation with the Electoral Commission, direct that such elections shall be conducted on the basis of the existing district in a manner to be known as the district block representation system instead of constituencies. The plain and irrefutable evidence before this court, as per the affidavits of the plaintiffs, is that there are present and existing constituencies in the country for parliamentary purposes. Seventhly, the multi-tier election on a proportional representation, as stated in the statement of the second defendant, finds no jurisdiction to either the Constitution of the country's laws regarding local authorities elections. Plaintiff's counsel's argument. In his argument before this court, Ghana counsel for the plaintiffs, Dr. Abdullahi Conte, submitted that this case was not about the merits of proportional representation system. At the heart of this case, he argued, was the crucial issue of whether the 2023 multi-tier elections involving parliamentary and local councils elections should be held through a proportional representation system, which he concluded strikes at the heart of the rule of law, in that whether we can truly say as a country we are governed by the rule of law and the Constitution of Sierra Leone. Further submitted that the proportional representation was not an alternative system of election in a democratic country governed by the rule of law. He argued that it was Section 38A1 of the Constitutional Amendment Act number 15 of 2001 that introduced such system, but that it must be read in conjunction with Section 81 of the Constitution of Sierra Leone Act number 6 of 1991, which had imposed a constituency-based election, in which case it must be concluded that Section 38A is not freestanding or alternate. Thus, he argued, the powers vested in Section 38A of the Constitutional Amendment must be exercised within the parameters of the Constitution Act number 6 of 1991, which provided that elections in constituencies based as in Section 38(1) thereof. He further submitted that apart from it not being freestanding, this case was about the limit of that power vested on the President and that of the Electoral Commission, and when and how that power to run elections by proportional representation system would be lawfully exercised. He submitted that it was against this factor that he was now submitting that the directive given by His Excellency the President to the Electoral Commission for each to run 2023 elections following the alleged consultation of the Electoral Commission to be altered by the Constitution. He noted that the plaintiffs were not questioning the directive per se, except that it was altered by the Constitution because there were already existing constituents. He was quick to note that the plaintiffs were further questioning whether the Electoral Commission was right in advising the President to make such a directive when the conditions listed in their estimation have strictly not been met or followed. In this context, the dependent's reliance on Section 50, Sub 3 and 171.14 of the Constitution was plainly out of context and misconceived. The court will no doubt and clearly be performing its role if it declared that the President was wrong in giving this directive when the conditions for holding general elections with proportional representation system have clearly in this case not been met. He relied on the case of Ijina on the application of Miller appellant versus the Prime Minister, respondent, Cherry and others respondents versus Advocate General of Scotland, appellant Scotland, where the Supreme Court in UK had to consider whether the Prime Minister's advice to the monarch was justifiable or not. He observed that this court would do well if it adopted the statement of Lady Hale when in paragraph 34 of the judgment said that, quote, if the issue before the court is justifiable, deciding it will not offend against separation of powers. The court will be performing its proper function under our Constitution, unquote. Turning to the issue of whether the conditions for the running of an election via district block proportional representation system were met, Learned Counsel for the plaintiffs urged the court to consider the two conditions precedent, which must be met as follows. Firstly, one, a date for the general election must have been fixed. Secondly, and most important, whether constituencies have not been established. He submitted that the determination of these two crucial issues must be based on evidence and analysis of the law, taking the above as the conditions which must be satisfied. He submitted that the answer to the first question as to whether a date had been fixed was in the affirmative. Yes, answer. Regarding the answer to the second question as to whether constituencies have not been established, the response he noted was that constituencies had long existed and were subsisting as evinced by the fact that members of parliament were currently sitting in parliament and that the first plaintiff hearing was the member of parliament representing one of the 132 constituencies existing, to which constituency 77, the block district in the northwestern region of the continent. He argued that on the contrary, there was no evidence in the portal of the fact that constituencies were existing to show that there were no constituencies existing as required by the preconditions for the use of proportional system of representation. Against the foregoing, he argued any decision to hold the election through proportional representation outside section 38(1) will be strictly unlawful. Learned Counsel for the plaintiff, Dr. Amlai Conte, concluded on this point by submitting that it would be most unusual and exceptional circumstance that would warrant the holding of a multi-party election through a peer system of elections and not when there is democracy. He argued further that it was incumbent on the Electoral Commission to cover reasons why it was necessary to change the form of election from a constituency-based first-past-the-post system to a proportional representation system. As far as he was concerned, up to this time, there has been no explanation given by the Independent Electoral Commission why it had to change the form of elections. submitted that the lack of explanation must be confusing to the electorate and the general public. In the alternative, however, it appeared he argued also that if there was an excuse of inability or impracticability to complete the exercise of the limited boundaries which the Electoral Commission of Sierra Leone had started, it was very lame excuse. That could only be accepted if the so-called excuse was made through an affidavit and subjected to scrutiny through cross-examination in the court. He submitted that the Electoral Commission has sought to extinguish constituencies unilaterally when such constituencies still subsist. Lanark Council then turned to the unconstitutionality of what he called statutory regulations, numbers 83, but indeed was statutory instrument numbers 13 and 14 of 16th November 2002, to which the Electoral Commission used to put the proportional representation system into effect or operation. Lanark Council submitted that the second respondent seems to take support in statutory instrument number 83 for the setting up of the PR system, but such a power cannot change the form or format of elections, noting and submitting that to change the format or form was a deliberate matter for the legislature in the primary legislation and not secondary instrument. Accordingly, to change the format of mode of election or statutory regulation, which is secondary, to be plainly altered by or that the word conduct does not include setting the format. We filed to Section 68 of the Public Election Act number 17 of 2022 to illustrate what constitutes regulation for conduct of elections, concluded by stating that because of the aforementioned, what Electoral Commission, the second respondent, second defendant, did by the said regulations through statutory instrument number 15, numbers 13 and 14 of 2022 was excess of their powers and accordingly altered by it. Therefore, urged such grant the reliefs paid for. The first defendant, statement of first defendant's case, first hearing to 92.1 of the Supreme Court Rules, 1982. Facts and particulars of the case. The first defendant, who is the Attorney General Minister of Justice, is the principal legal advisor to the government of Sierra Leone, including its ministries, departments, and agencies. The second defendant is the Electoral Commission for Sierra Leone, ECSL, responsible for the conduct and supervision of the registration of voters for and of all public elections and referenda, and for that purpose shall have powers to make regulations by statutory instruments for the registration of voters, the conduct of and other matters connected therewith, including regulations for voting by proxy. The second defendant, in compliance with its constitutional mandate, Constitution of Sierra Leone, Act number 6 of 1991, hereinafter referred as the Constitution, on the 21st day of October 2022, issued a press statement in which it stated that on the directive of the President of Sierra Leone, 2023 multi-tier elections to be conducted using the proportional representation system as provided for in Section 38A(1) of the Constitutional Amendment Act of 2001, Act number 15 of 2001, and that the boundaries limitation exercise, which are commenced, is halted if satisfied with the press statement of the second defendant. On the 28th day of November 2022, filed an originating notice of motion to the Supreme Court of Sierra Leone pursuant to Section 1241 of the Constitution. The main plank of the plaintiff's case is that to conduct the 2023 elections on a distinct block in Section 38A1 of the Constitution as the reasons for the Constitutional Amendment Act 201, which amended the Constitution introduced in Section 38A, are presently not subsisting. Sections 38 and 38A of the Constitution provides for constituencies and the election of members and prescribe which process and under which conditions they should be carried out. That the President, in consultation with the ECSL, has directed that such elections shall be conducted pursuant to Section 38A in a manner to be known as the district block system. Additionally, the ECSL has the powers to cause a review of constituency boundaries at intervals of not less than 5 years and not more than 7 years. Section 38.4 states, quote, Electoral Commission shall review the division of Sierra Leone into constituencies at intervals of not less than 5 and not more than 7 years, and may alter the constituency in accordance with the provisions of this section to such extent as it may consider desirable in the light of that review. Unquote. Further, Section 38B and the proviso thereof deals with how constituency boundaries should be determined. The population quota, as referred to in the proviso, is defined in the Constitution to mean the number obtained by dividing the number of inhabitants of Sierra Leone by the number of constituencies into which Sierra Leone is divided under Section 38 of the Constitution. Therefore, to delimit boundaries, the first thing to do is to divide the population of Sierra Leone to determine the population quota, and thereafter the population quota will now determine constituency delimitation. See subsection 6 of Section 38 of the Constitution. To ascertain the population quota, reference should be made to the latest population census. See subsection 7 of Section 38 of the Constitution. Therefore, the undermentioned facts since the 1991 Constitution was enacted, for which we ought. Therefore, the undermentioned fact since the 1991 Constitution, for which was enacted, for which we ought the court to take judicial notice of, ought to be borne in mind as we make our submission. A population and housing census was conducted in December 2004. B, thereafter constituencies were reviewed, altered, and delimited in 2007 by the National Electoral Commission, thus establishing 112 constituencies for the purpose of electing members of Parliament for the 2007 general elections. C, another population and housing census was conducted in December 2015. D, constituencies were again reviewed, altered, and delimitation done on the 17th February 2017, based on the 2015 population and housing census. Wherefore, 132 constituencies were established for the purpose of the 2018 election for members of Parliament. In July 2021, a midterm population and housing census was conducted. F, the results were announced on the 15th of September 2022, showing substantial growth in the population figures at regional, district, and chiefdom levels. G, the date for elections for members of Parliament was announced by the President to be on the 24th of June 2023. H, constituencies have not been reviewed, altered, and delimited to be so established for the purpose of June 2024. The 24th June 2023 general elections. The Electoral Commission cannot, after the 23rd of December 2022, update and revise the voters register due to the provision of Section 18 of the Public Elections Act 2022, Act number 17 of 2022, and Article 2 of the ECOWAS Protocol 1201 supplementary to the protocol relating to the mechanism for conflict prevention management, released in December 2001. Nevertheless, it is the contention of the plaintiffs that the conduct of June 2023 multi-tier public elections based on the district block representation system pursuant to Section 38(1) of the 1991 Constitution, as amended in the absence of a condition listed, namely, quote, where constituencies do not exist, unquote, will be ultra-vires and unlawful. The plaintiffs argue that the trigger for the district block representation system is where constituencies do not exist, unquote, quote unquote. They are certain that there are extant and subsisting constituencies and local council wards pursuant to Section 38(1) of the Constitution, the Local Government Act of 2004, Act number 15 of 2004, urged the court to so hold. Submissions. It is a submission that the plaintiff's assertion, based on their interpretation of the provisions of Sections 38 and 38A of the 1991 Constitution, cannot hold in law. The provisions of Section 38 and 38A are being deliberately misconstrued by the plaintiffs. We hereby submit a legal argument and interpretation of Section 38 and 38A of the 1991 Constitution as thus. In the instant case, the provisions in Section 38A were triggered after there had been a population and housing census and the results are now, with a significant alteration in the population group of the Electoral Commission for Sierra Leone could not review the limit and establish constituencies for the election of members of parliament slated for the 24th of June 2028. The midterm census was conducted in July of 2021 and the final results announced on the 15th of September 2022. Prior to the publications of the final census result, the President announced the date of the general elections, which was slated for June 2023. That the Electoral Commission, after a consultative meeting with the President on the 19th of October 2022, updating him on the progress relating to the boundary delimitation exercise being undertaken and the impracticability of complying with Section 38B of the Constitution, necessitated the directive of the President. This directive, so given, was done by an authority conferred on the President by the Constitution under Section 38A(1) of the Constitution, now amended. The wordings of Section 38A(1) inter alia clearly states, quote, where under any law for the time being in force, a date for a general election of members of Parliament has been appointed, but constituencies have not been established in accordance with subsection B of Section 38 for the purposes of such election, the President may, after consultation with the Electoral Commission, direct that such election be conducted on the basis of the existing districts in a manner to be known as the block representation instead of constituencies. Section 38(3) states that, quote, the boundaries of each constituency shall be such that the number of inhabitants thereof is as nearly equal to the population total as is reasonably practicable, unquote. Section 38(7) states, quote, for the purpose of this section, the number of inhabitants of Sierra Leone shall be ascertained by reference to the latest census of the population of Sierra Leone held in pursuit of an act of parliament, any available information, which in the opinion of the Electoral Commission best indicates the number of those inhabitants, unquote. It is a submission that the latest census in Sierra Leone is the midterm census conducted in 2021, for which final result was announced on the 15th of September 2022. Based on the said census results, there was significant population growth from 2015 to 2021 in the regions, districts, and chiefdoms by 6.4%, see page 37 of the final census result, which necessitated a review of constituencies pursuant to section 38, 3, 4, 6, and 7 of the Constitution. Since the Commission was unable to continue the constituency's boundary delimitation exercise based on the census, on the latest census result, and the date of the election of members of parliament has been appointed or announced by the President on the 24th June 2023, and the President having had consultation with the Electoral Commission on the impracticability of reviewing, altering, and delimiting constituencies, it is therefore prudent for us to reason, and we do submit, that legally constituencies have not been established for the forthcoming election of members of parliament pursuant to section 38(3) of the Constitution. Emphasis, right? It is fair and just and legal for the President to perform his constitutional duty by directing that the district block representation system used instead of the constituencies. In effect, the application filed by the plaintiff and the second relief prayed for is contravening the provisions of section 53 sub 3 and 171 sub 14 of the Constitution. These provisions state thus. 53(3), quote, whereby this Constitution or under any other law, the President is required to act in accordance with the advice of any person or authority. The question whether he had, in any case, received or acted with such advice shall not be inquired into by any court, in any court, unquote. 171(14) provides as follows: where under any provision of this Constitution, any person or authorities of the right or required to exercise any function after consultation with some other person or authority, the person or authority shall not be required to act in accordance with the advice of that other person or authority. And the question whether such consultation was made shall not be inquired into any court, unquote. That this court must have jurisdiction to grant orders prayed for on the subject matter before it, and that without jurisdiction, the whole proceedings become null with no legal effect. That by virtue of the restrictions placed in the above provisions in paragraph 6 thereof, this court has been deprived and lacks the necessary jurisdiction to adjudicate on the second relief prayed for, thus subjecting the President's directive to scrutiny by the court, which is legally wrong. Where the boundaries have not been reviewed to determine the actual inhabitants with reference to the latest census, that is the midterm census, an election on constituency-based system will be in complete violation of the Constitution, particularly so when the date of election has been announced. The argument by the plaintiffs that there is no condition precedent to invoke section 38A is flawed, baseless, and frivolous, and cannot be legally countenanced by this court. The impracticability to comply with section 38, 3, and 7 of the Constitution triggers the invocation of section 38A. It is the defendant's submission that section 38A was never introduced into our laws with specific purpose, as averred by the plaintiffs in paragraph 17, 25, 26, and 27 of their statement of case. Had it been so, it would have been repealed and replaced immediately after 2002 elections. But the drafters of that provision envisioned a situation where there would be a census, but constituencies have not been reviewed, altered, limited, and established. Hence, the essence of section 38E. If the drafters wanted to limit the applicability of the provisions of section 38A to a one-off situation, they would have said so clear. Furthermore, if it were to be believed that the 2001 amendments to the Constitution was as a result of the war, that would have been wrong, because it would have gone against the principle of austerity, which is one of the objectives for which the Constitution, as in this case, the Constitution of Sierra Leone. See the preamble to the Constitution of the United States. It is further submitted that contrary to the misplaced reasons proffered in paragraphs 17, 25, 26, and 27 of the plaintiff's case for the 2001 Constitutional Amendment, the actual reason for the amendment to Section 38 of the Constitution was necessitated by circumstances, quote, circumstance emphasis in which the Electoral Commission finds itself in a situation where a population census has been conducted, a date for the general election announced, for the Commission is reasonably unable to review, alter, limit, establish constituencies for the purpose of such election. Following the population and housing census in December 2004, the Electoral Commission conducted a review of constituencies in 2006, wherefore the constituencies were altered, delimited, and 112 constituencies established for the purpose of the 2007 general elections. The plaintiffs argued that the elections for ward councillors cannot be lawfully and properly held on the basis of proportional representation. We adopt our arguments in paragraph 1 to 10, the necessary modifications to wards. Wards boundaries were reviewed and delimited for the creation of 394 wards in 2008 after the 2004 census. We state that by the provisions of Section 33 of the Constitution, the Electoral Commission is empowered to make regulations for local councils, elections, and constitutional instrument number 82 of 2008 vests the authority to review wards based on the national population quota, which is ascertained by reference to the latest census. In this case, the latest census is the midterm census. It is therefore a submission that the constituencies and wards ought to be reviewed for the delimitation and establishment of wards for the purpose of the June 2023 elections, local council elections, as a result of the midterm census. The plaintiff's argument in paragraph 23 and 24 of the case states that the proportional representation system will negate the possibility of having independent candidates for such election. This assertion is speculative and not legal. Section 75 of the Constitution sets out clearly the requirement for a person to be elected as a member of Parliament, irrespective of the form of the electoral system so used. Once those requirements are fulfilled, nothing stops a person, be it independent or not, from being given the opportunity to contest. To buttress this point, Section 58(1) and 8(c) states, quote, a candidate shall be nominated in writing by 3 voters of the electoral area for which he intends to contest. And 58(c) states the political party of a candidate as applicable. This simply means not all candidates will be nominated by political parties. The plaintiffs further failed to establish their locus with respect to their case for independent candidates. The plaintiffs are both members of the All People's Congress Party and not independent candidates. They have not established a standing as to this argument, and therefore we submit that their argument with respect of it must not be entertained. That the applicants are further seeking this court to declare statutory instrument number 83 and 83 dated 16 November 2022 based on the argument that the Electoral Commission has acted in excess of the powers conferred under Section 33 of the Constitution and Section 171 of the Public Elections Act. It is a submission that the statutory instruments were laid in the House of Parliament on the 23rd of November 2022 by the Office of the Attorney General and Minister of Justice, pursuant to the provisions in Section 2 Subsection 3 of the Constitutional and Statutory Instrument Act 1999 states that any instrument so laid before Parliament shall have the force of law after 21 days unless before that date it is so defeated by vote of 2/3 majority. The said instruments are yet to have the force of law when the plaintiffs were yet to have the force of law when the plaintiffs filed the application to have it set. The application filed is dated the 28th November 2020. That is 5 days after it was laid before Parliament. They have not met any of the requirements for the document to be mature, and yet the applicant is seeking this court to act in vain by declaring it ultra vires. Can this court declare an instrument which is yet to have the force of law ultra vires? Conclusion. By reason of the submissions here, the orders page stated 1 to 9 by the plaintiffs in the originating notice of motion dismissed cost to the first defendant. First defendant's counsel argument. Counsel's argument. Both defendants opposed granting of the release fee. In the case of the first defendant, we relied entirely on the submissions made in the statement of the first defendant's case filed on the 8th of December 2022. In particular, with regard to the unconstitutionality of statutory instrument numbers 13 and 14 of 16 November 2020, they argue that at the time of filing this coordinated notice of motion, that instrument was yet law. But as of now, the instrument has received certificate of maturity and is now law, in which case it cannot be regarded as unconstitutional. Turning to the issue of whether the conditions precedent for the holding of elections to PR, which related to the first, second, third, fourth, fifth, and sixth today, the first defendant's counsel, Solicitor General, argued that the plaintiffs were not reading Section 38A in full, and that a full reading of it would no doubt bring into focus that it was not, that constituencies do not exist, or that they have not been established in accordance with subsection B of Section 38 of the purpose of such elections. This is argued brought into focus census and is relevant in the limitation of boundaries of the constituencies. It submitted that a midterm census was concluded with results published in September 2022, which result definitely necessitated a review of the current existing constituencies. However, because of the Equal Protocol and Section 18 of the Public Elections Act, number 17 of 2002, it was impossible to conduct any exercise to the boundaries without offending the aforesaid provisions. They argued that the advice from the Electoral Commission and the directives given by the President that within the mandate of the law provided in Section 38A. On the issue of independent candidates, Mr. Kowa, the Solicitor General submitted that no independent candidate has brought a claim before this court, and for that issue to have been raised by non-independent candidate was against the principle established in a normal case on local standard, as the so-called plaintiff lacked local standard. He argued further that assuming that the court was inclined to consider the belief that the statutory instrument numbers 13 and 14 have made adequate provision for independent candidates in Regulation 10. Counsel for the plaintiff, Mr. Osman Kanu, submitted that this Honorable Court lacks jurisdiction to grant the relief claim, to which a declaration that the directives by the President to the Electoral Commission of Sierra Leone to hold any public elections for ordinary members of Parliament violence, where there are extant and subsisting constituencies. Relying on sections 53, sub B, and 17114, he argued that the court could not inquire into how that directive was given. He noted the submissions of counsel for the plaintiff and the case relied upon, but noted that unlike England, which has an unwritten constitution, Sierra Leone was bound by a written constitution. He therefore asked that the declaration be refused. Regarding relief 7, 8, and 9, he noted that these were all consequential reliefs which would flow if this court were to grant August 1, 2, 5, and 6. Lastly, he noted and submitted that the plaintiffs have not complied with Rule 89 sub 2 with regards to the affidavit file. Statement of the second defendant's case pursuant to Rule 92(1) of the Supreme Court Rules 1982. The second defendant file is like 54 paragraphs. Paragraphs 1 to 30, 38, 39, and 40 are reduced hearing verbatim. The rest I will make reference to as and when necessary. Facts and particulars of the case. The second defendant is the Electoral Commission for Sierra Leone, ECSL, responsible for the conduct and supervision of the registration of voters for and all public elections, referenda, and for that purpose shall have powers to make regulations by statutory instrument for the registration of voters, the conduct of presidential, parliamentary, or local government elections and referenda, and other matters connected in addition to that, including regulations for voting by proxy. In order to carry out its concern mandate, the Constitution of Sierra Leone Act No. 6 of 1991, hereinafter referred to as the Constitution, the second defendant issued a press release on the 21st of October 2022, in which it stated the President of Sierra Leone has directed that the 2023 multi-tier elections will be conducted using the proportional representation system as provided for in Section 38A of the Constitutional Amendment Act of 2001, Act No. 15 of 2001, and that the boundaries delimitation exercise, which are commenced, will be halted with immediate effect. Dissatisfied with the press statement of the second defendant, on the 28th of November 2022, the plaintiffs herein filed an originating notice of motion to the Supreme Court of Sierra Leone pursuant to Section 124 of the Constitution. The plaintiff's argument are centered on the contention that conducting the 2023 elections on the district block representation system would violate Section 38A of 1 of the Constitution. The issues and situations that should trigger utilizing provisions of the Constitutional Amendment Act 1, which amended the Constitution by introducing Section 38A, are presently not subsisting. Sections 38 and 38A of the Constitution provide for constituencies and elections of members of Parliament and do prescribe proportional representation. The second defendant submits that the President of Sierra Leone, in consultation with the ECSL, directed that the 2023 elections be conducted according to Section 38A in a manner to be known as the district block representation system. Additionally, the second defendant has powers to cause a review of constituency boundaries at intervals of not less than 5 years and not more than 7 years. Section 38.4 State Code, the Electoral Commission shall review the division of Sierra Leone into constituencies at intervals of not less than 5 and not more than 7 years, and may alter the constituencies following the provisions of this section to such an extent as it may consider desirable in the light of the review unquote. The constitutional provision of 38.3 and the proviso thereof deal with how constituency boundaries delimitation should be determined. The population quota referred to in the proviso is defined by the Constitution as the number obtained from dividing the number of inhabitants of Sierra Leone and the number of constituencies into which Sierra Leone is divided under Section 38 of the Constitution. Therefore, to delimit electoral boundaries, the first thing to do is to divide the population of Sierra Leone by the number of seats in Parliament to determine the population quota. Thereafter, the population quota will now determine constituency delimitation. See subsection 6 of Section 38 of the Constitution. To ascertain the population quota, reference should be made to the latest population census, or if no census have been held, by reference to any available information, which in the opinion of the second defendant best indicates the number of those inhabitants. See subsection 7 of section 38 of the Constitution. From the outset, the second defendant would like to state the following fact for the attention of the court. A population and housing census was conducted in December 2004. B, and it triggered the review, alteration, and delimitation of constituencies in 2006 by the National Electoral Commission, thus establishing 112 constituencies to elect members of parliament of the 2007 elections. C, a second population and housing census was conducted in December 2015. D, again, the population and housing census of 2015 repeated the same process where constituencies were again reviewed, altered, and the delimitation approved by Parliament on the 17th February 2017. Based on the 2015 population and housing census, 132 constituencies were established for the 2018 elections for members of Parliament. In July 2021, midterm population and housing census were conducted with the results announced on the 15th of September 2022. This statistic shows that there was a significant change in the population with substantial growth in the population figures at regional, district, and chiefdom levels. The President announced the date for the election of members of Parliament for the 24th of June 2023. At this stage, constituencies had not yet been reviewed, altered, and delimited based on the trend and practices shown above, that after every census, the outcome should lead to the delimiting of boundaries for the forthcoming elections of the 24th of June 2023. The second defendant is legally barred from updating and revising the voter registration by Section 18 of the Public Elections Act 2022, Act number 15, Act number 17 of 2022, and ECOWAS Protocol on Democracy and Good Governance, ASP 1-1201, supplementary to the protocol relating to the mechanism for conflict prevention management, resolution, peacekeeping, and security, December 2001. Therefore, the condition precedent presented itself for the second defendant to advise the President that it was impracticable to run a proper constituency-based election. The advice was because, firstly, wrongly placing people into constituencies, and secondly, a complete boundary delimitation. A central contention of the plaintiff is that the conduct of the 2023 multi-year public elections based on the district block representation system pursuant to Section 38A of the 1991 Constitution, in the absence of the condition precedent, namely where conditions do not exist, quote unquote, will be otherwise and unlawful. The plaintiffs argue that the trigger for the district block representation system is, quote, where constituencies do not exist, does not exist. Plaintiffs further assert that there are extant and subsisting constituencies, and local council works according to Section 38(1) of the Constitution and the Local Government Act of 2004, Act number 15 of 2004, which should be made for forthcoming elections. Submissions. The second defendant submits that it has acted according to the provisions of the National Constitution, electoral laws, and the law governing census in Sierra Leone. The second defendant further asserts that the plaintiffs are giving a narrow interpretation of sections 38 and 38A of the 1991 Constitution. Sections 38 and 38A should be unrestricted to the post-war situation or any specific situation. The said sections apply to a litany of eventualities where constituency elections are either practicable or impossible. We submit a legal argument and interpretation of section 38 and 38A of the 1991 Constitution as thus. As the sole body responsible for conducting elections and with more profound knowledge of the intricacies of undertaking boundary delimitation, The 2022 midterm population and housing census heralded demographic shifts that altered the population of Sierra Leone from 53,000 to 57,000 population. This triggered the need for a review of the existing boundaries, delimitation of shifted current constituencies, and establishment of new constituencies for the upcoming 24th of June 2023 elections. The second defendant submit that One Statistics Sierra Leone, the only legal institution responsible for housing and population census in the country, has successfully conducted a census. Boundaries are bound to be delimited. Sufficient examples start with the events leading to the 17th of February 2017, when boundaries were delimited based on the 2015 census. There were 112 parliamentary seats in 2012. By 2017, while the House of Parliament was still in session, the ECSL, by the powers conferred on them by Section 38B of the 91, reviewed the boundaries of the constituencies. This led to a significant movement of people and the creation of 20 more constituencies to the existing constituencies. As a result of the fact that the President announced the election dates for the 24th of June 2023 to respect the Constitution's mandate of 5-year limit, it became practically impossible for the Electoral Commission to complete an unquestionable delimitation within the timeline fully. Therefore, in consultation with the President, at a meeting on the 19th of October 2022, in which the President was briefed on the progress and challenges of fully practicalizing the mandates of Section 38B, the President directed that the second defendant conduct the elections in June 20 on a proportional representation basis. Thus, the district block system for which this interpretation is sought. Section 38.3 states that, quote, the boundaries of each constituency shall be such that the number of inhabitants thereof is as nearly equal to the population quota as is reasonably practicable. The wording of Section 38A, among other things, clearly states that, quote, but constituencies have not been established under subsection B of Section 38, unquote. The said subsection of Section 38 provides that the electoral boundaries of each constituency shall be such that the number of inhabitants there is as nearly equal to the population quota as is reasonably practicable. To determine this population quota, the 1991 Constitution directs 38, quote, the number of inhabitants of Sierra Leone shall be ascertained by reference to the latest census of population held in pursuance of Act of Parliament. It is further submitted that on the 17th of February 2022, the boundaries delimited in 2017 reached the 5 years minimum threshold. The law allows the government through statistics to conduct a housing and population census to show the correct and accurate habitation of the people of Sierra Leone. This led to a mid-term census, and once statistics presented, the census, once statistics presented, the census of the second defendant, it was bound to reveal the boundaries of the existing constituencies to ensure elections are conducted on the accurate population density and as representative of the sparseness of the population. The only figures that will generally represent the present-day Sierra Leone population shall come from the latest census. Census figures are and it will be erroneous and unfair to leave those recent statistics and use an old 2015 census count. The 1991 Constitution is very instructive when it provides in Section 38.7 that, quote, for the purposes of this section, the number of inhabitants of Sierra Leone shall be ascertained by reference to the latest census of the population of Sierra Leone held in pursuance of an act of parliament, or if no census has been held, by reference to any available information which, in the opinion of the Electoral Commission, best indicates the number of those inhabitants. It is clear from the figures of the midterm census that a significant population shift and growth in specific regions, districts, and chiefdoms have occurred, and which makes it imperative for ECSL to review the boundaries that constitute the constituencies as provided in section 38B, 4, 6, 7 of the Constitution. It is the second defendant's informed position that there was and is a need to review the existing boundaries due to the shift in population. The 2017 electoral boundaries cannot be regarded as legal because they have to be established under the recent census and cannot inform the population distribution for the forthcoming elections. The second defendant's legal role is to advise the president on what is doable, feasible, and practical, considering all the circumstances at a given time, advising the president on the proportional representation system in the face of the impracticability of limiting the boundaries, but fair, just, and legal. Based on the impracticability of fully complying with section 38.3, the second defendant, with the advantage of unique and specialized knowledge information, advised the president of the eventuality of section 38A. The president so directed in exercising was triggered, and the president was bound to exercise his powers under section 38A by giving the directives as he did to the ECSL. While the state will argue this, ECSL believes that the directives given by the president touching on using a district block representation system of the June 2023 elections were done in good faith, followed the dictates of the spirit, letter, and intent of the wordings of section 38A of the 1991 Constitution. The wording of section 38A, among other things, clearly states, quote, where under any law for the time being enforced, the date for a general election of members of parliament has been appointed, but constituencies have not been established in accordance with section 3 of section 8. Such election, the president may, after consultations with the Electoral Commission, direct that such elections are conducted based on the existing districts in a manner to be known as the district block representation instead of constitution. Constitution provides that elections shall be held every 5 years, and a date has been announced for that effect, where the boundaries have not been so reviewed to determine the actual inhabitants with reference to the latest census. That is the midterm census. An election on the constituency-based system will be in complete violation of the Constitution, particularly so when the date for the election has been announced. Any election held leaving out a midterm census would not only be illegal, but a flagrant violation of constitutionalism, which underscores the spirit of democratization. The second defendant will argue that the constituencies and wards cease to exist since statistics Sierra Leone legally conducted country's population centers under the power conferred on them by law. To counter the existing midterm census in zone, a new census has to be undertaken, or the extant midterm census will be declared illegal by competent bodies with the power to do so. It is the second defendant's position that in the absence of legitimate boundary delimitation by the second defendant, elections for both ordinary members of parliament and local council can only be conducted according to the provisions of section 38A of the 1991 Constitution. The plaintiffs argue that there is no condition to invoke section 38A, as explained in paragraphs 5, 6, 7, 8, 9, and 10, mere impracticability of limiting boundaries in the face of a significant shift in the population density in the country is enough for a condition precedent to surface and summon section 38A. The point is moot displaced blood, and should be discounted by the court. The second defendant submits that the provisions of Section 38A are neither transient nor transition. It was not introduced into a law just for the war situation, as the plaintiffs in paragraph 17, 25, 26, and 27 of their statement of case have said. The draft of new conditions will occur when constituency elections will be practicable and a remedial provision was needed. If they wanted additional transients, they would have said so. It is also the defendant's submission that in 2016, in the final report by the Constitutional Review Committee, made up of 80 members, including representatives of all political parties, they all agreed on pages 260 to 61 that the proportional representation system was a more democratic way to conduct an election for members of parliament. That there are over 80 stable democracies that practice different forms of proportional representation. Among these countries, we have Switzerland, where most of the United Nations offices are housed and which has enjoyed peace and stability since the First World War. Rwanda, one of the most peaceful, prosperous democracies on the continent of Africa, now have gone through a brutal civil and tribal war. New Zealand, Norway, Spain, to name a few. The plaintiff's submission that the PI is not conducive to a democratic civilian government is factually, material, incorrect, and aimed at deceiving this honorable court into accepting the case. This court should not countenance this argument. Second defendant counsel's argument. In his argument, second defendant's counsel did say he rely on what the first plaintiff has said in addition to what people say. In his argument, defense counsel Dr. Emmanuel Safa Abdullah concentrated on the reason why the Electoral Commission was compelled to take the action of advising the president and the fact that the plaintiff's counsel had said that there was no reason or the reason being very weak. He posited an 8-part test to determine whether the second defendant, the Electoral Commission, acted beyond its powers as follows. 1, whether the Electoral Commission acted reasonably. 2, whether the Electoral Commission had followed due process. 3, whether it was within the limit of that institution to do what they did. 4, whether the decision is national and evidence-based. 5, whether the decision was taken in good faith. 6, whether the decision was published after it was taken. 7, whether the decision served proper purpose. And 8, whether proper consultation was made. He submitted that the decision of the Electoral Commission met all these requirements. Turning to the issue of local government, submitted that there has never been a law for local government elections, except in the Public Elections Act and through regulations which are made pursuant to Section 3 of the Constitution of Sierra Leone 1991. He concluded that with the new census result, it was necessary to delimit boundaries of constituencies, which the Electoral Commission was unable to do because of ECOWAS Protocol and Section 18 of the Public Elections Act 2022, which meant that laws for elections must be settled before 6 months to the elections, and to use the current constituencies will be most undemocratic, as it would exclude a lot of people who have been captured by the recent census, which was showing an increase in population of 57,000 plus people spread across various districts and localities. Urged the court to refuse the reliefs paid for. That is what they have said. How is that done? Consideration of the issues. The issues to be determined in this case are as follows. 1, whether on a proper and purposive interpretation of Section 38A of the Constitutional Amendment Act number 15, 2.1, the controlling provisions stipulated in subsection 1 thereof, namely, but constituencies have not been established, are conditions precedent to warrant or justify the holding of general elections of ordinary members of parliament. By district block system, herein also referred to as the proportional representation system. 2, whether the directive of the President to the Electoral Commission of Sierra Leone, ECSL, to hold any public elections for ordinary members of parliament by the proportional representation system where there are extant and subsisting constituencies is altered by the Constitution Act number 15/201 as amended. 3, whether the current parliament was itself elected on a constituency basis as provided for in section 38(1), 2, and 3 of the Constitution Act number 6 of 1991, and that these constituencies are still extant and subsisting. 4, whether the revision of constituencies as provided for in section 38(4) does not necessarily result in the establishment of constituencies stipulated in section 38(1), 2, and 3, but rather the section provides for the period when existing constituencies should be reviewed, which revision may or may not necessarily result in the delimitation of the respective boundaries of existing constituencies. 5, whether relying on section 38A of the Constitutional Amendment Act number 15/201 will preclude independent candidates from contesting for parliament as contemplated in section 77M of the Constitution 1991. 6, whether the entirety of section 38A of the Constitutional Amendment of 201 does not provide or contemplate local councils proportional representation elections, whether the word basis on which local councils are elected is the subsisting and only lawful basis on which any public elections involving local authorities can be held, not a proportional representation system. 7, whether section 2 of statutory instruments numbers 14 dated 16 November making provisions for representation by both members of parliament and local councils is altered by section 33 and 38 of the Constitution Act number 6 of 1991. I will now deal with these issues serially. Whether on a proper and purposive interpretation of section 38A of the Constitutional Amendment Act number 15/201, the controlling provisions stipulated in subsection 1 thereof, quote, but constituencies have not been established, are conditions precedent to warrant or justify the holding of general elections of ordinary members of parliament by the district block representation system, hereinafter referred to as the proportional representation system. In the consideration of this issue, one will note first that the plaintiffs are arguing that the controlling provision is namely, quote, but constituencies have not been established, and that this is a part of the condition, this is part of the conditions precedent which must be established and which has not been established. Hence, the reason why proportional representation at this point in time, when according to them constituencies do exist, cannot be applicable or be the mode or form of elections for the 2023 elections, and by extension, do not justify the holding of elections by such means as adopted via the public announcement, via the press statement of 21st of October 2022. This is clearly seen from the plaintiff's argument, wherein they have sought to present it thus, that as a result of the provisions of section 38(1) of the Constitution Act number 15 of 2001, it would be ultra-vires that provision and unlawful to hold the June 2023 multi-tier public elections continue via a proportional representation system using the district block system. But as they put it, the plain and simple reason that the condition precedent according to them for bringing into effect those provisions in section 38A are quote unquote where there are no constituencies, which at this very moment is not the case in the county courtesy of the fact that there are extant and subsisting constituencies in operation pursuant to section 38(1) and 2 of the Constitution. That is to say, the trigger, according to them, to bring proportional representation into operation is, quote unquote, where constituencies do not exist. And as is explicit to all concerned, there are consistent constituencies existing, 132, of which the plaintiff is the representative or member of parliament for constituency number 77 in the local district. Predicated on the above, the district block representation has already been put into place by the Electoral Commission, will be altered by the very provision which establishes such a system of representation in Parliament, in consequence of which they are seeking the assistance of this court to stop the Electoral Commission from carrying out the district block representation system in place of the constituency-based form of representation, which has usually been the case. The defendant's reply is that the plaintiffs have given a very restrictive meaning of section 38(1) of the Constitutional Amendment, and that section 38A has never, in fact, provided, as they are arguing to be the case. They claim section 38A(1) has not stated or never stated where constituencies do not exist, but that rather that section be read as a whole, to wit, where under any law for the time being in force, the date for a general election of members of parliament has been appointed, but constituencies have not been established in accordance with subsection 3 of section 38 for the purpose of such election. The President may, after consultation with the Electoral Commission, direct that such elections shall be conducted on the basis of the existing district in a matter to be known as the district block representation system instead of constituencies, unquote. They submit that without the fresh or new delimitation of constituencies after the publishing of census results by Statistics Sierra Leone, legally speaking, constituencies have not been established for the forthcoming elections of members of parliament pursuant to section 38A of the Constitution as amended. And that this is exactly the way they are read, hence the position of the district block system. Section 38E of the Constitution Act number 6 of 19 provides, quote, the boundaries of each constituency shall be such that the number of inhabitants here is as nearly equal to the population quota as is reasonable fact, provided that the number of inhabitants of such constituency may be greater or less than the population quota, in order to take account of means of communication, geographical features, density of population, distribution of different communities, areas and boundaries of chiefdoms and other administrative and traditional areas, unquote. The defendants infer from this section that by the words, but constituencies have not been established, is not saying, quote, quote, but constituencies do not exist, or where there are no constituencies, as the plaintiffs are arguing, but rather that constituencies have not been established based on the current population trend as stated by the recently conducted census, which does and will always affect population quota and the eventual boundary delimitation of constituencies and the number of constituencies for purposes of elections. The defendants refer to section 38(6) and 7, which goes on to explain the population quota as mentioned in section 38(3), which is the controlling section as to how such constituencies must be established for purposes of elections. the 2023 elections not being an exception. This is a process which will take time, as explained by the Second Defendant's Counsel in paragraph 11H and 17 of the Second Defendant's case, and also beyond their control, with the recent publication of census results by Statistics Sierra Leone. The second defendant on their own had started a review pursuant to section 38.4, but with the population census figures received, it became necessary to establish population quota and delimit boundaries, which was going to take time, noting the law, section 18 of Public Elections Act number 17 of 2022, and the ECOWAS Protocol on Democracy and Good Governance, supplementing to the protocol to mechanism for conflict prevention management, Article 2.1.1 under elections, which states, quote, that no substantial modification shall be made to electoral laws in the last 6 months before the elections, except with the consent of a majority of political actors. They will not be able to meet those timelines. From the above, it's clear to me that there are two positions regarding the true meaning of Section 38A and its applicability. This calls for interpretation, and this is what plaintiffs have sought to invoke by their seeking of the aforesaid declaration pursuant to Section 124 of the Constitution. Interpretation meaning of an enactment by giving the terms of any enactment its actual or true meaning. As a court or as judges, we do not interpret arbitrarily, but according to set standards and rules developed over the ages called rules of interpretation. The scope of our work in part of this judgment is to discover, design, and decipher the true meaning of Section 38A as expressed explicitly or implicitly in the language used. Taking the above into consideration as a mandate, I say that on the full reading of Section 38A, it shows the section has 4 parts. Condition precedent. 1. We are under any law for the time being enforced a date for a general election of members of parliament has been appointed. Condition precedent number 2. But constituencies have not been established in accordance with subsection 3 of Section 8 for the purpose of such election. Advised by the Electoral Commission, the President may, after consultation with the Electoral Commission, powers of the President, direct that such elections shall be conducted on the basis of the of the Supreme Court, as she then was, in the unanimous decision of the Supreme Court of Ghana in the case of Anti and Ajua against Ogbo, 205 to 206, Supreme Court Ghana Law Report 494 at 504-505 explained the assistance to be gathered from headings and marginal notes in the interpretation of a statute in the following terms. Quote, as clearly provided under Section 4 of the Interpretation Act 1960, the comparable section of Section 15 of Act 792, headings to parts of the statute, do not form part of the statute. They are intended for convenience of reference only, but the useful role they play in statutory interpretation is not disputed. Headings which will be described as signposts are a useful guide in determining the scope or ambit of the provisions to which they relate. Quote, given its plain and ordinary meaning, quote, but constituencies have not been established, is saying, but constituencies have not been set up, inferring a setting of process in accordance with Section 38B as the controlling provision, hence the word in accordance with. This setting of process begins with a census which is out of the Electoral Commission's reach of control within the limit of statistical. 2, boundary delimitation of constituencies under which Electoral Commission will aim, establish a population quota pursuant to Section 38B and 38.6, which according to the Constitution is number of inhabitants, census results divided by the number of current constituencies. 3, gets the proposed boundary delimitation of constituencies approved by the current Parliament for use after the dissolution of Parliament and the next election. This, to my mind, is the reason why it is stated in Section 38(1), but constituencies have not been established in accordance with Section 38(3) for the purpose of such elections. Unquote. Taking the whole Section 38 and 38A into consideration, this court holds that the default position is that for elections of ordinary members of Parliament, there must be constituencies. However, to establish constituencies, it is not an issue of being of a number and dividing districts into such numbers. It is based on several factors, like first and foremost, population census, population quota, number of current constituencies, and the like. And where the Electoral Commission is unable to establish constituencies based on these dictates, the alternative is for them to advise the President on such status who may or may not directly as within his power the form of election who may or may not direct as within its power that the form of election be part of constituency based to a district block representations using the existing districts. This is what Parliament did by its Constitutional Amendment Act number 15 of 2001. The purpose, as quite seen in the annotation hereto, and from the Act itself, is for a district block representation system. It is not a one-off situation, but one which might come up if the establishment of constituencies are not done well in advance of time to be taken into consideration during voter registration and long before 6 months to the elections. Since 2001, governments have come and gone. Parliament did not repeal it. They even had an opportunity to repeal same when the Speaker brought it to their notice. Pursuant to Section 108, it is not an intent provision which required cumbersome process to change. But they did not change Section 38A. Parliament is the law-making body. If they had wanted, they would have done it. This they did with the restoration of the right of appeal in court-martial cases in 2005, following the denial of that right since 1971. As judges, we can only interpret what we see, and that is what I have done. What is important in any election is the citizens' right to vote. It has not been affected, and it will not be affected, no matter the system, whether constituency-based or district block representation system. Having tested these provisions on the literal meaning, which is clear and unambiguous, I think it is far better if I move one step further and try to confirm it on a modern approach, the purposeful interpretation. In legislation and statutory interpretation by Carl and Claire Markens, third edition published by LexisNexis, learned authors wrote, quote, since the 1980s, the court's approach to statutory interpretation has significantly changed. Today, courts are statutorily required to consider both the meaning of the words and the purpose behind the legislation. And this has led to a more balanced and effective approach to resolving ambiguity. The purposive approach means the court must give primary importance to the purpose or object underlying legislation when interpreting provisions of an act. In the case of Abu Ramadan against Nimakor Electoral Commission and Attorney General 2023-2024 to Supreme Court, Ghana Law Report 1654, the Supreme Court of Ghana stated regarding portions of the public elections registration of voters regulation 2012 CI 72 Awuje in part as follows, quote, established principles of statutory interpretation require that CI 72 be read as a whole, not piecemeal and purposely construed and with the impugned legislation interpreted in the context of the other parts of the code of CI 2072. To this end, I take sections 38 and 38A as a whole and hold that the purpose of this section is clearly establishing two systems of voting. One, constituency-based form, first past the post. Two, a district block representation system with proportional representative. Any of same may happen depending on the prevailing circumstances at hand. Having regard to its object and purpose as agreed from the annotation and the purpose for which this amendment was put in place, it does not present to my mind any such difficulty in interpreting as to warrant us departing from or adding to the ordinary sense of stand, and I give effect to every word of it. From the totality of the interpretation, taking sections 38 and 38A into consideration, one can easily conclude that where there is a population census, number of constituencies are likely to change. They are likely to change, as evidenced from the fact that in 2004, a population and housing census was conducted in December 2004, based on which constituencies were delineated and or established. 112 in total for the purpose of electing ordinary members of parliament for the 2007 election. For the 2012 elections, there was no population census, hence no change in the number of constituencies, which remained the same at 112. Things were so static that in section 56 of the Public Elections Act number 4 of 2012, it stated members of parliament shall comprise 112 members. However, in 2015, there was another census which resulted in the altering of the population data and of voters. The resultant effect was that despite the Public Elections Act number 4 of 2012, which had stated categorically in section 56, that members of parliament shall be 112, because of the primacy and supremacy of the Constitution Act number 6 of 1991, and how constituencies ought to be established via the process to elections, constituencies had to be established based on the census of 2012. This was done on the 17th of February 2017 and formed the basis under which the 2018 elections were conducted based on 132 established constituencies instead of 112 constituencies that had hitherto existed based on 24 census and by operation of law, the Public Election Act number 4 of 2012, section 56 thereof. The census results used were published 3 years before the elections of 2018. And also the limitation of boundaries was approved in 2017, about a year or more, and most importantly, before the announcement of the date to the election. This, no doubt, is different from what we now have, where the date for the elections had been announced 15 months before the set date for the elections. Also in 2021, a midterm population census was conducted, for which the results only came out on the 15th of September 2022, after the date for the election had been well appointed in advance since March 2022. And one can take judicial notice of the fact that in September 2022, registration of voters was ongoing. The natural thing to happen was for the Electoral Commission to now delimit constituency boundaries. This, according to the second defendant, was to take time, paragraphs 11 and 17 of the second defendant's case. The defendants were objected to review constituencies pursuant to section 38(4) when the census results were published, taking its implication on board to which establish population quota, delimit constituency boundary, get parliament to approve, say, get voter registration to reflect such constituencies and wards. Such was likely not to meet the deadline of 24 December 2022, set by section 18 of the Public Elections Act 2022 and the ECOWAS Protocol on Elections. The process had to be abandoned in favor of a district block under which the Electoral Commission believed they will meet timelines. In the exercise of their functions, the Electoral Commission is guided by section 32(11), which guarantees them independence in the exercise of their function, and we are inclined to support and uphold that independence. In this case, it is for the plaintiffs to show something either in the nature of the subject matter or in the context in which the words are used, which compels this court to come to a different conclusion from the grammatical sense. They have not done that. If anything, on the doctrine of harmonious construction, one can easily see that there could have been no other interpretation better than that which we have adopted. The doctrine of a rule of harmonious construction is to the effect that a provision in the Constitution or statute should not be interpreted or construed in isolation, but as a whole, so as to remove any inconsistency or incongruence. Under this rule, there is obligation placed on the courts to avoid a clash on contradicting provisions, and courts must construe the opposing provisions in a way as to harmonize the conflicting provisions. The doctrine is based on the principle that every statute or the Constitution does have a purpose, and the provisions should be read in totality and not in compartmentality. The doctrine may become necessary for application where there arises inconsistency between sections of a particular statute of the Constitution. After the statute or act of parliament has been passed, the legislation no longer has jurisdiction and is functus official. We being interpreters are then unable to question or get back to the legislature to request the exact interpretation of the legislature while they were making it, or even sometimes they may not have even considered such broad range of circumstances at the time of drafting or consideration. In Commission of Income Tax against MS Hindustan Bulk Carriers 2B BSS 57, page 74, the Supreme Court of India, Commonwealth country, have persuasive laid down 5 principles that govern the rule of harmonious construction as follows. 1, firstly, courts should try and avoid a conflict of seemingly disputing provisions. An effort must be made to construe the disputing provisions so as to harmonize them. 2, the provision of one section cannot be used to overthrow the provision covered in another section unless the court is unable to find a way to settle the differences despite all efforts. 3, in a situation where the court finds it impossible to entirely reconcile the differences in inconsistent provision, the courts must interpret them in such a way that effect is given to both provision as far as possible. 4, courts must also take into consideration the interpretation that takes one provision, that makes one provision redundant and useless is against the essence of harmonious construction. 5, harmonizing 2 contradicting provisions does not mean you render them fruitless or destroy any statutory provision or render it ineffective. Could it be doubted that if we go by the plaintiff's interpretation, this would render Section 38A redundant and ineffective for all times? That cannot be the intention of Parliament. If they want that, they are lawmakers. They must change the law. Remove that law from our books. Until that is done, Section 38A cannot be freestanding, ultimate, or a one-off situation. There can be no doubt that while we have two separate sections to dealing with two separate forms of conducting elections, that interpretation we are giving makes Section 38A to fit in nicely and in sync and harmoniously with Section 38 to be applied when the circumstances in the context as of now as stated, and I say no more. Second issue, whether the directive by the President to the Electoral Commission of Sierra Leone ECSL to hold any public elections for ordinary members of Parliament by the proportional representation system where the extant and subsisting constituencies is altered by the Constitutional Act number 1521 as amended. That Council for the Plaintiff has respectfully submitted that Section 38A1 of the Constitution does not give the President carte blanche power or conditional authority to direct that the elections be held on a proportional representation system, regardless of whether the conditions precedent were fully met. He claims that because there were extant and subsisting constituencies, the so-called advice by the Electoral Commission was wrong in law, and so too the directives which emerge, even though as per Section 53.3 and 171.14 of the Constitution, a court cannot inquire into the consultations where the directives were based on a supposed wrong presupposition to which that constituencies have not been established, when according to him, constituencies have existed and were still subsisting. This court has jurisdiction to make a declaration that the President acted beyond his powers. The defendant's response was that this court lacked jurisdiction to so declare because of Section 53.3 and 171.14 of the Constitution. This court does state that it has jurisdiction to hear what the plaintiff's inquiry is all about. Our inquiry is not whether His Excellency the President has received or acted with such advice, but whether the directive given by him is in tandem with and intra-vires the law as prescribed, which the President himself as fountain head of justice and primary upholder and defender of the Constitution is enjoined to observe, or whether his action to direct the Electoral Commission to use the district block representation system for the 2023 June elections was outside or in excess of the power so conferred on him by Section 38A1 of the Constitution. In Regina against Hall University Visitor Ex parte page, 1993-2, appeal cases 237. Brown Wilkinson said in defining what is meant by ultraviolence, quote, if the decision maker exercises powers outside the jurisdiction conferred in a manner which is procedurally irregular or is willfully unreasonable, is acting altered by his powers and therefore unlawful. Quote, taking the above into consideration and having come to the conclusion that the preconditions or condition precedents are fully met, His Excellency the President's action are therefore procedurally regular and willfully reasonable, making the inquiry academic. In that sense, in that those directives were well within his mandate and were lawfully made and can in no way be declared as ultra-violence. Third, inquire whether the current Parliament was itself elected on a constituency basis as provided for in Section 1, 2, and 3 of the Constitutional Act number 6 of 1991, and whether these are still extant and subsist. The plaintiffs are seeking declaration as a way of interpretation and enforcement of the Constitution that the current Parliament was elected on a constituency basis as provided for in Section 38, 1, 2, and 3. There can be no doubt that this was the case. Even when Section 56 of the Public Elections Act number 4 of 2012 provided that the current Parliament after 2012 was to be 112 members, the evidence before this court is that following the 2015 census, which altered Sierra Leone's population of that which was the case in 2004, the number of seats in Parliament and constituencies MPs have changed from 112 to 132 as a result of boundary elimination or delimitation exercised in 2017, which flowed from those census results. See paragraph 11, from each of the first and second defendant's case. When that happened, the previously 112 constituencies lasted up and until the dissolution of that parliament for the 2018 elections, which saw the establishment or introduction of the new constituencies approved by that old parliament. Those previously 112 constituencies, by and large, by the dissolution of parliament, became extinguished. Land Council for the second plaintiff, Dr. Emmanuel Safa Abdullah, has submitted in paragraph 27 of the second defendant's case that the moment census results are declared, it extinguishes constituencies. I will not go as far as that, except to state that with a new district block system of representation on the horizon and in place for the next election, it automatically means that the current constituencies will be rendered redundant at the dissolution of the current parliament, except for calculating the population quota when that time comes after the forthcoming elections by the new parliament. The effect here is that these current constituencies, for purposes of representation of the people in parliament, can never be extant and subsist after the forthcoming dissolution of parliament and for purposes of the forthcoming elections. Fourth issue, whether the revision of constituencies that provided for in section 38(4) does not necessarily result in the establishment of constituencies stipulated in section 38(1), 2, and 3, but rather the section provides for the period when existing constitution should be reviewed, which revision may or may not necessarily result in a delimitation of the respective boundaries of existing constituencies. Section 38(4) provides as follows: the Electoral Commission shall review the division of Sierra Leone into constituents at intervals of not less than 5 and not more than 7 years, and may alter the constituencies in accordance with the provisions of this section to such an extent as it may consider desirable in the light of the review. There is a proviso which states that the Commission may at any time carry out such a review and alter the constituencies in accordance with the provisions of this section to such extent as it considered necessary in consequence of any omission in the number of members of parliament referred to in paragraph 3 of subsection 1 of section 74 by reason of the holding of the census of the population of Sierra Leone in pursuant of an act of parliament. The revision of constitution as provided in section 84 would definitely result in the establishment of constituencies, even though it is a power given to the Electoral Commission to review and alter, which can be exercised even when there is no consensus. When there is alteration in the population, the proviso to that section 38(4) of the Constitution states that the review is a matter of must and ought to be done without reference to the time, that is, whether within 5 to 7 years period or at any time. Either way, any review by the Electoral Commission pursuant to section 38 of the will most invariably be affecting the number of constituencies subject to parliamentary approval as the last final form. Whether relying, issue number 5, whether relying on section 38(a)(1) of the Constitutional Amendment Act number 15 would preclude independent candidates from contesting for parliament as contemplated in section 77(m) of the Constitution 1991. The plaintiffs have submitted that if section 38(a)(1) is put into operation by applying the district block proportional representation system, there's no way by which independent candidates be afforded an opportunity to represent people In the affidavit attached to the plaintiff's originating notice of motion, the first plaintiff deposed at paragraph 10 thereof that, quote, such a system constricts the political space for people minded to contest election as an independent candidate as provided for in section 77M of the Constitution, unquote. In their case, too, it is noted that paragraph 23 and 24 respectively provides as follows. Quote, it is further submitted to the plaintiff that the use of proportional representation for public election would negate the possibility of having independent candidates for such election as is contemplated in section 77M of the Constitution, which relates to the loss of an elected independent seat on cross-carpeting to a political party. 24, moreover, it is the case for the plaintiff that the proportional representation system gives primacy to a political party's list submitted to the Electoral Commission to the exclusion of the constitutional entitlement of every Sierra Leonean subject to the requirement listed in section 75 of the Constitution 1991 to be entitled to be eligible as a candidate for parliament. The response by the other side, both defendants, is that the plaintiffs, being both members of the APC party, are not independent candidates and consequently do not have a local standard to institute this action. They rely on the case of Norman against Dr. Sama Bami and others, S205 and reporting. According to the editors of Constitutional Law of South Africa, Chapter 8, page 83, the concept of local standard is concerned with whether a person who approaches the court is the proper party to present the matter and issue to the court for adjudication. The word quote, standing has been referred to as metaphor used to designate a proper party to an action, a court action. An inquiry into standing should thus focus on the party who brings the matter before the court, not on the issue to be adjudicated. In his book, Civil Procedure in Nigeria, second edition, page 32, under the rubric, as the person intending to sue the local standard, Fidelis Muangialo had this to say, quote, the term local standard denotes legal capacity to institute legal proceeding in a court of law and is used interchangeably with terms like standing or title to sue. It has also been defined as the right of the party to appear on behalf of the question before any court or tribunal. It is the right or competence to institute proceedings in the court for regrets or assertion of the right enforceable in court, unquote. In the case of Samuel Hinga Norman against Dr. Sama Bami and others, on report quoted by the defendant's solicitors and counsel, lack of local standard was used by the Supreme Court to throw out the third and fifth belief in the originating notice of motion of the plaintiff. Relying on the Nigerian Supreme Court decision of Senator Abraham Adesanna and the President of the Republic of Nigeria, 1981, all Nigerian law reports 1, the Supreme Court used the strict meaning instead of the modern and liberal approach to throw the matter out of force. In that case, action was brought by the appellant, challenging the constitutional validity of an appointment made by the President of Nigeria. The action was dismissed by the Nigerian Supreme Court on the sole ground that the appellant had no local standard to bring the action as there were no rights, peculiar or personal to him, which had been infringed. The court did not even go into merits case and issues for local standard was taken in limine. In Judgement against Attorney General Bandu Civil Suits number 4/2001, the Supreme Court of the Gambia did the opposite, where it held that the plaintiff, being a citizen suing in the Supreme Court, alleging contravention of the 1997 Constitution, need not prove particular interest in alleging contravention of the Constitution, and that a citizen is entitled under Section 5(1)(a) and (b) to challenge contravention of the Constitution. In that case, the dictum of Jalo, JSC, United Democratic, number 1 against Attorney General, number 1/1997 to 201, Gambia Report 789 at 803 was applied. As follows, quote, every citizen of the Gambia is competent, subject only to express restrictions and limitations. to seek redress in the court against alleged violation of the constitutional order. That competence vested in the general citizen is not diminished by one's status as a legislator. The situation might have been different if the plaintiff had voted in favor of the measure, but he cannot then be allowed to mount a legal challenge to what he has expressly supported and approved as a legislator. Plaintiff as a citizen did not need to demonstrate any particular interest in order to vest in local standard, bring the instant action alleging contravention of the 1997 Constitution. In the course of that judgment, while the JSC said this, a transgression or violation of the Constitution by the government is a law committed against the whole country and its citizens. Even the Supreme Court of the United States is noticed now to be shifting from the strict adherence to the local standard rule to the legal emphasis of the court's function as a protector of public interest in the enforcement of constitutional limitation, and will no longer be deterred by the mere play of local standard from considering a challenge to violation or transgression of Constitution. This court is inclined to follow the modern liberal approach, despite the strict adherence which has been upheld by this court in the Hinoman's case. As a matter of judicial wisdom, the Supreme Court of Sierra Leone, under Section 122 sub 2 of the Constitution, while treating its own decision as normally binding, may depart from a previous decision when it appears right to do so. Behold, that the member of parliament is a citizen of the country without which he would not be a member of parliament, and this is a matter of public interest in the enforcement of the Constitution. That apart, it is noted that our parliament, by enacting the provisions contained in Section 127 of the 1991 Constitution, made it possible for the first time for a privately person to institute proceedings to challenge the constitutional validity of any enactment, as well as to challenge the validity of anything done under the authority of the 1991 Constitution, any law, without requirement that the person should show that he has a legal right or interest, personal or peculiar to him, which has been adversely affected by the act of omission which he seeks to challenge. This accords with as it is and is in tandem with those provisions. Having said that, it behoves me to go into the merits without striking the guilt out as would have been if I uphold the local standard argument. In this regard, the defendant solicitors went forward as to argue that the claim is a mere speculation. This being the case, we do agree that such consideration that independent candidates will be unable to take part was only speculative, as in the statutory instrument number 13 of 2022, now in force dated 16th November, there is ample provision for independent candidates to contest election. They will nonetheless be representing the whole district instead of just a constituency. And the percentage of votes he or she secures is what will make him or her to be seated in parliament. As long as an independent candidate fulfills the requirement as stated in section 75 of the in terms of qualification, fulfills the requirement for nomination, wherein he is nominated in writing by 3 voters from the electoral age, where he or she intends to contest the election. See section 10 of SI number 14 and section 58 of the Public Elections Act number 17 of 2022, and complies with other regulations as detailed in section 70 of SI number 14, dealing with apportioning of seats to political parties and independent candidates, which provides as follows: quote, where the valid votes cast for an independent candidate results in that candidate winning more than one seat, the extra seat or seats shall be assigned in accordance with the highest remainder formula for apportioning seats to political parties or independent candidates or group. He or she is entitled to stand, contest, and can win a seat in the proportional representation district block system. 6th issue, whether section 2 of the statutory instrument number 15, dated 16th November 2022, making provision for both representation for both members of parliament and local councils, is altered by section 33 and 38 of the Constitution Act number 6 of 1991. The Plaintiff's Counsel, in his statement of case, has made a heavy weather of the unconstitutionality of the regulations, noting that it is primary legislation that can determine the form of legislation and not subsidiary or secondary legislation. The Plaintiffs' Counsel, in his statement of case, has made a heavy weight of the unconstitutionality of the regulations, noting that it is primary legislation that can determine the form of legislation and not subsidiary or secondary legislation. The power given to the Electoral Commission under Section 33 of the Constitution Act number 6 of 1991 and Section 171 of the Public Election is to conduct and supervise elections and not to determine the form or mode of elections. He stated categorically. He concluded by stating that because of this, what the Electoral Commission, the second respondent, did by regulations titled SI 13 and 14, published 16 November 2022, was in excess of the Electoral Commission's powers and accordingly authorized. He went to state further that they did not even give any explanation for what they did. Firstly, this argument cannot be supported in view of the fact that it was primary legislation that brought the amendments to the Constitution Act number 6 of 1991 in the form of Constitutional Amendment number 15 of 2001 into force. This was clearly the work of Parliament in the primary legislation titled Act number 15 of 2001 as opposed to a subsidiary or secondary legislation. Government after government remained steadfast with the provision, not choosing to abandon it, but to keep it within our laws. Secondly, and most importantly, it would appear the Learned Council has downgraded the effect of regulations as laws of the country. Under Section 171C of the Constitution of Sierra Leone, it is stated that the laws of the country shall comprise inter alia, quote, any orders, rules, regulations, and other statutory instruments made by any person or authority pursuant to power conferred on that behalf by this Constitution or any other law, unquote. It's clear to me that those regulations and laws of Sierra Leone made by or through the contribution of Parliament, as they are laid before Parliament, and will only become law on the expiry of 21 days after being so made without objection, unless before the expiration of 21 days, Parliament annuls same by 2/3 majority. Yes, they are secondary legislation, but still laws of the country. And a better way to making laws when an emergency and technical expertise is required, except that it must conform to the principal authority, the primary legislation, where the authority to make the law emanates. Thirdly, Learned Council has categorically stated that using Section 33 of the Constitution Act number 6 to put into operation the district block representation system, those regulations are stated in section in statutory instrument number 13 and statutory instrument number 14 of 16 November 2 is in excess of the powers granted by those provisions and accordingly authorized. He relies on section 124 of the Constitution, which B part says where any question arises whether an enactment was made in excess of powers conferred on Parliament or any other authority referring to the Electoral Commission or person, chairman, ECSL, by law or under the Constitution. Quote. It states in no uncertain terms that the power given to the Electoral Commission under Section 33 of the Constitution and Section 171 of the Public Elections Act number 17 of 2002 is to conduct and supervise elections and not to determine the form of elections. In order to determine whether such assertion is postulated by Learned Council is correct, Section 33, it is noted, provides as follows. Subject to the provisions of the Constitution, the Electoral Commission shall be responsible for the conduct and supervision of the registration of voters for and of all elections and referenda and for that purpose shall have powers to make regulations by statutory instrument for the registration of voters, the conduct of presidential, parliamentary, or local government elections and referenda, and other matters connected therewith, including regulations for voting by proxy and vote. The question that begs an answer is what is the extent of the Electoral Commission's powers, and whether by this enactment of the regulation via statutory instrument numbers 13 and 14 they exceeded those powers. My task, therefore, is to conduct a judicial review of the Electoral Commission's actions via the creation of statutory instruments numbers 13 and 14 of 2022 on the one hand. That is, whether there has been a breach of the statutory constitutional requirements by putting it into effect or force, by putting into effect or force SI numbers 13 and 14 of 16 November 2022. On the other hand, also, noting the plaintiff's counsel has made a heavy plea of the fact that the Electoral Commission did not give reasons for the action, or simply that the reason given was very lame and weak, one must ask whether in fact they acted wisdom. That is, whether their actions were procedurally regular or winspear unreasonable. See the case of Associated Provincial Picture Houses Limited against Winspear Corporation, 1948, 1 Kings 22, 2, see also Jaina Ghetto University Visitor Expert page, 1993 to AC. In the case of Council of Civil Service against Minister of State for Civil Service, popularly referred to as the GCHQ case, 1985 AC, U74, the House of Lords stated that the grounds for judicial review may be subsumed under 3 headings. A, illegality, simply decisions not within the institution or commission's powers. B, irrationality, attesting to the fact of the decision being reasonable, and where the Winspear principle becomes relevant. Thirdly, C, procedural impropriety, alluding to the process, whether due process was done or the decision was effected in disregard for the rules of natural justice. The deep clock in the GCHQ case noted that by irrationality, I mean what can be succinctly referred to as the Winspear unreasonableness. It applies to a decision which is so outrageous in its defiance of logic and of accepted moral standards that no reasonable person who has applied his mind to the question to be decided could have arrived at it. Whether a decision falls within this category is a question that judges by their training and experience do well equipped to answer, unquote. Thus, whether or not a decision falls within the ambit of this category is a subjective test and depends on interpretation of the judges. Judge or judges are hereby set out to conduct the inquiry on these terms. Regarding the first inquiry on the Electoral Commission's powers, this can be gleaned from the Constitution, and these are from Section 33. 1, for the conduct and supervision of all elections and referenda. 2, for the conduct and supervision of the registration of votes. 3, to carry out 1 and 2 above do have powers to make regulations by statutory instrument or A, registration of voters, B, the conduct of presidential, parliamentary, and local government elections, and then 4, to carry out 1 and 2 above to make regulations for matters incidental and connected with presidential, parliamentary, and local governments, including regulation for voting by proxy. Section 33 starts with subject to this Constitution, unquote. Consequently, there are other functions detailed in this Constitution, which are not necessarily stated in Section 33 of the Constitution. And these include A, Electoral Commission shall review the division of Sierra Leone into constituents at intervals And to what people are that cannot just think of other plans, see, control observative, exercise power to regulate or govern by to have a controlling interest. This is quite expansive. Tell me somebody who is in control, who cannot determine the form for what is under his control. Surely that person is a lender. A pastor in charge of a church will tell you this is the form a particular service will take. And it goes on and on. Also, that list in section 68 referred to is not exhaustive, as brought out by section 68B of the Public Elections Act 2022 state code. During an election, the agreement under this section and other enactments relating to the electoral process general and other enacted emphasis mark. It is but clear to me that the Electoral Commission, second defendant, by making those statutory regulations, never exceeded its authority as given by both Section 3 and Section 71 Public Election Act, dealing with the role of function. On the and 40 of the defendant's case, which I quote with approval, it does not in any way undermine our democracy. Whether the entirety of Section 38A of the Constitutional Amendment of 2001 does not provide nor contemplate local councils elections, and whether the broad basis on which local councils were elected is the subsisting and only local basis on which any public elections involving the local councils can be held, and not the proportional representation system. A close look at Section 38A1 of the Constitutional Act number 15 of 2001 shows that this primary legislation has not made any provision for local councils. Thus, on the face of it, it appears as if there is no provision for proportional representation in local councils elections. Provisions for election of members of parliament through a constituency-based system of elections, we show also that it only made provision for elections of members of parliament without provision for local councils. Section 38(1) of the Constitution of Sierra Leone Act number 6 of 1991 provides: 1. Sierra Leone shall be divided into constituencies for the purpose of electing the members of parliament referred to in paragraph B of subsection 1 of section 74 of this constitution as electoral commission acting with the approval of parliament signified by resolution of parliament prescribed. 2B. Every constituency established under this section shall return one member of parliament. In 208, despite members of parliament alone, because of the provisions of section 33, which deals with the functions of the electoral commission and reads as thus, quote, subject to the provisions of this constitution, the electoral commission shall be responsible for the conduct and supervision of the registration of voters for and of all public elections and referenda, and for that purpose shall have powers to make regulations by statutory instrument for the registration of voters, the conduct of presidential other matters connected therewith, including regulations for voting by the courts. The then Electoral Commission, being faced with a situation of having to delimit works for local council members or councillors, was constrained to put into motion Constitutional Instrument number 2, published on the 17th of January 2008, titled The Constitution of Sierra Leone Act No. 6, 1991, Words, Boundaries, Delimitation, Regulations 2008. In that body of legislation, it states, in exercise of the powers of Constitution 1991, the Electoral Commission makes the following regulations. It is by part of these regulations that we now have words, boundaries delimited for local councils. And this is so despite the seeming distinction of constitution dealing with constituency-based election for MPs and the delineation of boundaries only for that purpose as per section 38. The form of format of election was brought about to a subsidiary legislation. And we are aware that any force was made to restore that a subsidiary election was due to effect such change when the guiding provision of constituency-based elections, the main provision did not only mention words or appear to consider local councils. In the case before me, in the one sense as regard ordinary members of parliament, the form of election has been long determined by parliament, when as a result of the presence of the condition in a proportional representation system became necessary as per law established and was approved by the president. With regard to local councils elections, I would say ditto. The same has happened as was the case in 2008. While the constitutional amendment has not said anything about local councils in section 38A1, in the spirit of that provision, through their functions as provided by section 33 of the Constitution, the Electoral Commission, whose mandate it is to conduct and supervise any public elections, have sought before Parliament through a subsidiary legislation to reach laying before Parliament and getting its approval after 21 days through the SI numbers 13 for local councils approved. Should we now, as a court, reject same? I should think not. The word conduct has been seen above is broad enough as to encompass all of this. Firstly, a precedent has been set, which I dare say is not only consistent with the Constitution because of section 33, but it's on all fours with what transpired in 2 leading on to the passing of the boundaries towards the limitation regulation 2008. Secondly, the Electoral Commission will not be acting outside its functions, which are well stated in section 33 of the Constitution Act No. 6 of 19, which has been well documented. Thirdly, by section 32, the level of the Constitution, in exercise of these functions, the electoral court is not subject to the control and direction of any person or authority. Consider this court hereby makes the following decisions. 1. That on the proper construction of section 38A, all conditions precedent for the holding up or conducting of general elections of ordinary members of parliament to a district block representative were met and fulfilled. 2. That the directive given by His Excellency the President to the Electoral Commission of Sierra Leone to hold 2023 elections, public elections for ordinary members of parliament in the district of representation system instead of constituencies was in tandem with the provisions of Section 38.1 of the 1991 Constitution, as amended and therefore not altered by us. 3. That the current parties currently existing distinguished for purposes of representation in Parliament in favor of representatives representing each of the 16 districts of Sierra Leone, inclusive of independent candidates who secure the minimum threshold for the attainment to securing of seats in Parliament. 4. That the revision of constraints are provided in Section 38.4 does lead to a restriction of the number and establishment of subject to parliamentary approval. 5. That independent candidates can and are part of the electoral system and can stand and be voted for to be included in any of the seats. Block proportional representation system is refused. Emphasis 1. 9. An order directed the second defendant to hold the June 2023 elections for ordinary members of Parliament and Council on a constituency or ward basis is refused. Emphasis 1. Cost. On the issue of cost, this court notes that this is a public interest-based litigation and hence is not inclined to award the usual costs. A minimal cost is therefore awarded, the sum of 3,000 euros to be borne by both plaintiffs jointly and severally payable to the first and second. Yes.
I have lordship here.
Yes.
May I, on behalf of my client, say we note and take under advisement the 53 odd pages that your lordship has read out this morning. A judgment that is full of promise and pregnant with possibilities. We will accordingly advise them. May I, with respect, if you allow me, to say we hope in the future administration of justice in this country, the same alacrity that has been displayed by no less than the Supreme Court in listing the case, hearing it, and determining it within 18 days of the conclusions of the arguments and submissions be attended with anticipate of future cases in court to ensure the peace, liberty, and tranquility of our republic. Thank you.
My Lord, once more, on behalf of myself and the defendant, first defendant, the Attorney General and Minister of Justice, we appreciate the judgment and we commend your industry in arriving at such a decision. Just a clarification. I hope it's with respect to the issue of costs, my lord.
Millions is 3,000.
That is
Millions is 3 million.
3 million. Thank you, my lord. We just want to bring to the attention of this court that this is the very first time the law of
will be free and fair on behalf of the second judgment, taking into consideration all of the arguments today. Thank you. No, we're not part of 3 million. You can take it. 3 million is quite enough for you guys. Thank you.
As the court. Thank you.